Blog Talk Radio.
Good evening and welcome to another episode of Financing Your Business. Today, I'm Tim Jacquet, your host, Vice President of Apple Capital Group. We have some technical difficulties at the moment, and our guest will be online shortly. Tonight's topic is, what should I do if I get arrested? Insight from a criminal attorney. While we're waiting for him to come online to be dialed in, I'm going to tell you about the upcoming episodes we have. Tomorrow at 8:30 a.m., we have a episode talking about federal grants. On Sunday, we have an episode on repairing your credit. On Monday, also later during the week, we will do some interviews at the liturgical conference in the Diocese of Dallas. Also, we have an interview with the Minority Business Council. On Friday, we have an interview on SEO, inbound marketing. Selling to the Government, Part 2. We have somebody from Fred Market is going to talk about selling to the government and the GSA schedule, certification, and so forth. Also, at the end of the month, we have an episode on asset-based lending. We're going to start breaking them down. One would be for factoring, an explanation on factoring, explanation on bad credit, what type of programs we have as a company to do back to get you approved. Today, we have from a banker. We'll start talking about small business loans and micro lenders. So that's going to give you a synopsis on what we have. This is a community service project from Apple Capital Group. If you want to dial into the conference bridge, the telephone number for guests call in is 347-342-3460, 347-342-3460, or you can chat online and post your questions there. To kind of give you some background on Jorge Sanchez is from Brooklyn, New York. He attended Halsey University in New York, where he received a BA in psychology and speech. Upon graduation, he had an opportunity to play professional baseball, turned it down, and to attend law school. Jorge accepted a scholarship at the University of Texas Law School. After receiving his JD, or his law degree, he passed the bar and began working as Assistant Attorney General. Where his passions lie is his poetry, his screenwriting, his acting. He's now the principal of his own Sanchar law firm, which is in Dallas, Fort Worth area. Also, to kind of give you some more information about Apple Capital, in the past we have several other episodes I think you want to take a look at on Blog Talk Radio. Business Networking was a great show. We had a lot of listeners, and a lot of people are still downloading that episode. That occurred on January 19th. I talked about business networking and the importance of business networking. Additionally, it was talked about BNI Group. Why should you join that particular group? Also, we had an episode on learning to take your company public. If you are a small business and you want to go up to that next level, listen to the episode and we'll talk about how to bring your business into the marketplace over the stock exchange. Either it's going to be a bulletin board or American Stock Exchange or New York, and to be elaborate. But you can do team sheets or over-the-counter market. Also, we had an introduction to search engine marketing. We had a guest to talk about his program, and also with his program, they give you a free trial for 30 days to try his product. He would do your search engine marketing for free for 30 days. If you want to retain him after that, he'll continue to work with you on your project. Also, we had an episode on community relations regarding how to integrate parolees back into society. It was a great show. Now we're getting ready to bring online Jorge Sanchez. Jorge, you there?
Yeah, I'm here.
Okay, well, welcome to the show. I guess just to begin with, just talk about where you're from and tell us about Jorge.
I'm sorry.
Just tell us something about yourself, where you're from, and talk about your firm.
Okay, I'm Jorge Sanchez. I'm born in the Bronx, New York, and grew up there. and I went to University of Texas Law School and came out here. And the first couple of years, I was an assistant attorney general trying cases for them and winning cases for them, and then started my own firm, the Sanchez Law Firm, which is a criminal defense law firm.
Wow. And when you was an assistant attorney general, was it on the criminal side or civil, or kind of tell us
No, it was civil. I was doing basically million-dollar cases for the state of Texas when they, like eminent domain, when they were taking property and there would be a lawsuit over the property, and I would be the one arguing.
Wow. So from there, you went straight into criminal law. What a transition.
Yeah.
Kind of tell us kind of scenario, once a person get arrested, what happens in that particular incident?
Well, when a person is arrested for whatever, meaning DUI or, driving with license suspended or, various other criminal offenses, initially they're taken downtown to bookkeeping and they're basically fingerprinted and the whole 9 yards. At that time, they can bond out. If their case is a bondable case, they can bond out. There'll be a bond set. And at that time, they can either bond out through a lawyer or a bondsman. And, from that point on, they can fight their case from, the outside, or if they don't have money, from the inside.
Okay. So from the once they get arrested, anything they should do, since a lot of people haven't been arrested, they just really don't know what to do. Is there certain things, should they say anything to the authorities, not say anything to the authorities, or?
If there was one thing I could ever relate to clients, is shut up. They should never, ever speak with law enforcement under no circumstances until they've consulted with their lawyer. When law enforcement tells them anything you say can and will be used against you in a court of law, they absolutely mean that. Yet, over and over again, people get nervous and begin to talk and say things that they don't need to say and give admissions that they don't need to admit. Also, consenting to searches and all that stuff, absolutely not. The only thing that you do is you comply with law enforcement commands as far as, let me see your driver's license, let me see your identification. But outside of that, anything other that they requested, you should want to talk to your attorney.
Okay. So, for example, if you're pulled over for a assumed traffic violation, and of course, you're always you're going to comply with what they ask for. You're going to give them your driver's license and insurance and registration. Should you say anything beyond that, or just simply say yes or no?
You absolutely should say nothing else. What they're going to do, in a simple traffic stop, is they'll do things like, where are you coming from? You're not under any obligation to tell them where you're coming from. You can tell them absolutely that it's my constitutional right not to tell you anything. I'm not going to tell you anything. And the thing about it, when I say can and will be used against you, if you tell them something that you commit and they don't believe you, or that against you and say that's a reason to continue to detain you because they don't believe you, or that maybe your passenger told them something different. So you absolutely do not want to talk with them at all.
Okay. So if they have a suspicion they say, well, can you step out of the car and can we search your car? Do you have to give them consent for that?
You do. They can't just, unless they see something in plain view which gives them probable cause, meaning they walk up to your car and they see an illegal substance, a narcotic in your car, or they see a gun sitting in your car, or they walking up to the car and they say they can smell the burnt odor of marijuana. These are reasons why they can search without your consent. However, if they don't see any of those things, they do not have the right to search your car. So you have the right to tell them no. So if they say, will you consent to a search? Absolutely not. Will you consent to a search of my purse? Absolutely not. Now, I don't drink nor smoke, but I would never consent to any search.
Okay, great. So saying yes or no, and if you say, well, I prefer not to say anything in a nice, that's what you're saying, say yes or no, just comply and say, well.
Absolutely. Have to be rude, but in the same respect, you have to be honest and straightforward and not waver, because once you tell them no the first time, that doesn't mean that they won't continue to ask, because their thing is to get you to talk and to get you to go against what you want to do. So what they'll say is, well, if you can give me consent, I'll let you go home. Well, if you do these field sobriety checks, we'll let you go home. That's a lie. That is an absolute lie. So you should say absolutely not.
And so what happens after that? If you say absolutely not, then what's their recourse?
If they decide that they want to search your car anyway, well, then now that's an issue that you have in court for an illegal search. They have to establish probable cause to search your car. And that's going to be difficult if you're not giving them, food for it, a reason for it. Meaning if you're not talking to them, you don't say anything to them. And if you don't do it, then they have nothing to have established probable cause.
Okay. So you can't say that you plead the fifth through the whole thing, or just be really nice to them and say, I prefer not to say anything.
I would say I have nothing to say. You have my driver's license, you have my insurance. The first thing you should do is, why are you stopping? That's the first question you ask them. But
Okay.
It starts the timeline running, because they have a certain amount of time that they can't have you out there all night, basically. So, what is your reason for you stopping me? Here's your life insurance. Where you come from? I'm not under no obligation to tell you that, and I'm not going to. And sit there and wait. Nothing. I consent to no searches.
Okay, so the time clock starts there. So they have a certain amount of time that they have to get this wrapped up, you're saying?
That's correct.
Okay. And now, if they come back and say, well, we have a warrant that means for a traffic violation, then it's a different story.
Yes.
And of course, you comply with them, but if it's a traffic warrant, that's something different. But if it's something else beyond that, then should they say, well, I want to speak to my attorney, I have nothing to say?
They should say, I want to speak to my attorney, no matter what it is. I don't care if they come back and say, well, you have warrant for speeding tickets, and we're going to take you in, and now we can search your car. Well, they can do an incident search, but there's restrictions on that. But at all times, no matter what the situation is, you should never speak to them.
Okay. For example, I know they have the difference of having felony or misdemeanor. Can you talk about the difference between a felony, between a misdemeanor, and a regular ticket, a citation or something?
Well, a citation is a ticket of Class C, which you can pay to fine. A misdemeanor, you can go from 0 to 365 days in jail. You can go up to a $4,000 fine. A felony, you're talking about it from a state jail felony, which you could go from 6 months to 2 years in a state jail, or from a third-degree felony, 2 years to 10 years in the penitentiary. A second-degree felony, 2 years, 20 years in the penitentiary, or a first-degree felony, which is 5 to 99 years in the penitentiary. So, clearly, a felony and misdemeanors, Class C tickets are nothing but fines. Felonies are much more serious than misdemeanors. So that's kind of the chopping block.
And that's definitely, you don't want to say anything. Well, you shouldn't say anything in any case, especially for that particular case. If it's something one charging you for looking like a misdemeanor or a felony, don't say anything at all.
I wouldn't say anything at all. I don't care from a Class C ticket to anything. I wouldn't say anything at all at any time.
Okay. Now, they can charge you, and then it takes a certain period of time for a person to get an indictment, is what I'm reading as well. So you can be charged with something but not indicted right away.
That's correct. It's going to be a while before you're indicted. They're going to file it. They're going to file the complaint. At that time, it's called an information. So it's not an indicted case yet, because in order for it to be indicted, they have to take 12 citizens in good standing of the community, and they have to hear a basic, rendition of the facts. And then they decide whether or not it should be true billed, which is indicted, or no billed, which is dismissed.
Okay. Now, during the charge, they can set for a bail hearing, right?
They can what?
For initial charge, then there's bail set from initial charge?
Yeah, well, they're going to set a bond at the jail when you're booked in. They're going to set a bond amount. Once the judge gets, what they call it magistration. Once the judge, which is a magistrate judge, once they book you into the jail and the charges have been filed by the police officer, the judge will then set the bond, and that could be based on what the case is and your criminal history. Okay.
And then you go from bail. And then indictment, between the charge and the indictment, it's just that's the final process, you're indicted? Or
once you're indicted, then you're in court. And then from that point on, it's between the district attorney and your attorney.
Okay. With the district attorney and the attorney, what's the expectation, the person, once they're arrested, now they're indicted, what's the expectation? I know you go to court and so forth. Can you talk about how that process normally happens? Now they're indicted, now they have a court date set. What's the expectation for them to go through this process? What the attorney is also expecting out of the client?
Well, the first thing you have as any criminal defense lawyer is going to tell you is money, pay your bill, because that's what happens. Clients are notorious for, having products like that. A criminal defense lawyer wants a client who is going to come to court. You cannot miss court dates. You cannot miss court time. And other than that, just a lot of times people watch too much TV and they think that they can practice law because they saw something on Boston Legal or, Law and Order. And unfortunately, that is not real court. I had a conversation with my client today in court today where he was saying, well, this is a weak case. And I said, no, it's really not. And what I informed him is that a case is different when you look at a trial, whether or not you want to take the trial. Because when you take the trial, then you got to think about things like, who's going to tell your side of the story? Can you really get understand? Do you really want to put your client in the stand? Because most defense attorneys do not. So it's a lot. The case looks a lot different when you talk about whether or not I'm going to take it to trial, as opposed to just making a plea negotiation. So most defense lawyers want their client to be compliant and listen to what they're telling them, because we know what we're talking about, generally speaking. Now, you do have some lawyers that are kind of, The flip side, what should a client expect? A client should expect that the lawyer tell them all of most importantly, that you tell them all of what can happen. Because I think that a lot of times lawyers will not tell, people exactly all of the facts about what could happen. And I think that's important.
Okay. So mainly it depends on the attorney. Hey, this is what's going to happen. This is what you're faced with, and these are your cards dealt with. And then from then, it's up to them to decide which direction they want to go to, right?
Right.
Okay. Now, the difference between a person who have a judge trial or a jury trial, it just depends on the case, or it depends on the person case itself.
That is a big difference. Can you hold on 1 second, please? Just 1 second.
Again, we have Jorge Sanchez with the Sanchez Law Firm. You can call in. The number is 347-324-3460, 347-324-3460. Or you can post your question in the chat room, and I'll be more than happy to go ahead and ask a question with Attorney Sanchez. One moment.
Tim?
Yes.
I'm sorry.
Okay.
I apologize to the audience. Okay, now the difference between a bench trial and a jury trial, there's a huge difference. You generally will never see a bench trial because bench trials, most lawyers, defense lawyers especially, do not want a judge to decide their fate, because judges, unlike juries, are not sympathetic. Judges are generally have seen everything and heard everything before, and they have a much more legal mindset of looking at a case. And generally speaking, they'll probably be a little bit more tougher on a criminal defendant. So generally speaking, a bench trial will be reserved. More misdemeanor cases will be resolved with bench trials than felonies. Felonies inevitably will be jury trials because a person that gets an opportunity to have their case tried in front of a jury of their peers for what's supposed to be different. And so, but when the case is decided, now that's when it switches, because we have a bifurcated trial system, which means that guilt innocence phase and there's the punishment phase. So a lot of lawyers will go to the jury for guilt innocence, but if their client is found guilty, then they'll go to the judge for punishment because they feel like the judge won't be swayed by emotional stuff that the district attorney will put up in front of them.
Okay. If you're a felony, definitely you want to go into a jury trial and take a chance. Then first of the judge.
Almost 99%, yes.
And with the jury trial, the defendant decides that, or just recommended by the attorney, or who decides?
The client always decides. So if the defense attorney can never choose a jury over a judge if the client doesn't want it. So his client has to basically say, I want a jury trial, I want a bench trial. Now, of course, the defense attorney is going to instruct and inform and encourage his client to go to a jury trial.
Okay, and take your chances there. Are juries persuaded by the background of the person? If the person say, hey, who, for example, let's take, never been convicted of anything, and are they persuaded by a person's background and say, hey, he grew up in this bad neighborhood and he had this influence of happening on him? Or you can really persuade a jury to try to tell this person's story to try to get what you can get out of for the best interest of the client.
That's a perfect example of Tim, that's a perfect example, and I'm glad you said it because it's a good question that a lot of people want to know, but it's a perfect example of the difference between a trial law and, the Boston Legal. you will never get your story heard. That is not what a courtroom is about. It will be objected to, and it will be held irrelevant, and it will be sustained, and you will never hear it. Court does not care less about what this person's story is, until it comes to punishment. At punishment, you can bring in this person's history and all that stuff, because at that point they're trying to decide the punishment, and you want to show who the person is and all that stuff. You can bring it up in punishment. But in the guilt-innocence phase, the only thing that is relevant to that case is what happened at that time, on that night. And that is the only thing that's going to be allowed into evidence. So if you attempt at the guilt-innocence phase to say, well, this person is from here, objection, irrelevant, sustained, and move on.
Okay, so in the guilt-innocent, in the punishment phase, as you mentioned, you still have the option for a judge, you have an option for a jury.
Yeah, but you have the option.
Okay, so they have another option.
Yes.
Once again, okay, I follow. So they have at the beginning, you can charge both, one or the other, and if you're guilty, then you can choose how you want to proceed from there.
That's correct. Now you have to decide before the trial.
Oh, yeah, before the trial.
Yes, you do. You have to file a motion before the trial saying, if my client is found guilty, we elect to go to the jury or we elect to go to the judge.
Okay. Then, like Boston Legal, as you mentioned, then the person's background and so forth will happen at the punishment phase. Nothing is entered while the trial is going on during the guilt or innocence. During the guilt and innocence, they really don't care about the person's background. It's the fact, and the attorney is mainly his job is to defend the person itself, but also what else their job is to try to help them. I'm not going to say get off the hook, but get them good representation.
The job of the defense attorney during trial is simply make sure, according to for his client, to somehow show that on that night in question, that his client did not violate the law. Okay. So through the cross-examination of the district attorney's witnesses, so the bottom line is your job is to protect your client's interest at any cost, basically by cross-examining witnesses.
Okay.
And putting on your own case.
Okay. And then, follow. Okay, now the other question, the last three questions regarding when you have an instance like, how does this play a part if it, like a domestic? I'm not sure if people get charged on domestic violence and it's really is a he said or she said type thing, and if the person doesn't show up, doesn't mean the case get dismissed or the state can go on and still go with it.
It depends. And Tim, it's funny that you say that because I think that, once again, the Boston Legal, I think that people have a misguided interpretation. I can't tell you how many times I've heard people say, well, that's just he say, she say. That's just his word against mine. That's what trial is every day, all day. That's all a trial is. Generally, you never have the smoking gun. That's very rarely you have the smoking gun. And that's not normally a trial. A normal criminal defense trial is there are some witnesses who are saying that this happened, and you have witnesses that say it didn't happen. That is a trial. He say, she say, and it's the jury's job to decide the credibility of the witness based on their questions. So that's the case every day. But as far as when you come to those cases are such problems because there are a group of them where a man or a woman may lie and just say it because they're mad. There are a group of them where a woman may be assaulted and she's scared because she's afraid of what her husband or friend or boyfriend will do, and so she'll lie and say it didn't happen. There's so many different variables. However, you said that he has to test. Well, it's a little bit complicated. The husband wants to have a husband spousal privilege, but when it comes to whether or not you testify, in fact, meaning if the police come to the home and they want to file an assault charge on him, but the man has left the house and they don't arrest him at the scene because they didn't ID him at the scene, well, then now the woman has to be present and she has to testify to the case in order for them to have a case because otherwise they don't have anybody to identify. But if it's different if he's there and they arrest him at the scene, then they don't need her to go forth with the case.
Okay. Yeah, if they see she battered and bruised and so forth, then that's what you're saying? It was quite evident or it's not? They still don't need the witness.
Say that again. Yeah, I'm sorry.
If they visibly walk into the residence, they see the place is torn up, they see that she's got black eyes and so forth, then that's good enough for them, or they still would need that?
No, they're gonna, if they come in and see if they come in and see someone abused, if they come in and see that, they're going to join. They're going to take pictures. They're going to jump to their own conclusions, and then they're going to talk to the witnesses. But if you have physical evidence like that, they most certainly will take that as evidence and then definitely arrest the gentleman.
Okay, I follow. Okay. Now, the last couple of things regarding child support is what it is. I mean, because you owe the surveillance, I mean, it's really not much of a defense to it. You just either pay it and negotiate it. How is that normally done in a that's not a criminal case, it's more of a civil case, right?
Yes, that's handled by the Attorney General.
Okay. With corporations themselves, like, for example, there was a company, they arrested an officer, that company for pirating. Corporations can also be held criminally liable, like a person?
A person in a corporation, yes. You know, they can, the white collar crimes that you have, yes. A corporation itself obviously can't be held for criminal charges, but a person hiring a CEO can suffer a criminal case through white collar crimes. Yes, that is true.
Okay, great. Last question. Any advice that you would have besides we mentioned earlier to a client, hey, you just have this issue, what would you say as an attorney? Hey, this is what you need to do in order to make this process to go smooth as possible, and I can do the best defense. What would you say to that person walking into your office?
Well, if they're walking into my office, of course, most people have no idea what happens in a courtroom, and it happens at a criminal trial or civil trial for that matter. And so what I would say is that you need to make sure that you research and get the attorney that is best for you. And sometimes you have to make sure that, you know, you may find there may be a good attorney, but they may not mesh with you because you may feel like you're not telling you enough. But the best thing for a person stepping into the office is that the process and the trial are not instantaneous. It take a while. It's going to be a long drawn out process. So brace up for the ride. And then the other thing is trust the professional who you're dealing with. You have to trust the lawyer to do his job, and then trust that he knows what he's talking about. And I would hope that you do hire a responsible lawyer, but you have to trust that he knows what he's talking about. I can't tell you how many times I can tell someone, listen, this is not a case that you want to try, and they think, oh, well, it is a good trial. No, it really isn't. And then, you know, they end up getting put in a position that they don't want to be in. So I think that you have to trust the professional and what you go with. Okay.
And so you're saying that in that case, hey, you don't want to go forward this, you just take the plea and go on. Okay, and then go from there.
You know, it's funny. When I was doing civil trials, a reputable lawyer once told me, he said, trials are for unrealistic lawyers. And he said, because you should really never go to trial. Everything should always be settled. But one person has greatly overestimated their case. If you bring that into the criminal world, generally speaking, the only time you're going to trial is the district attorney is being unrealistic about their case, or you're being unrealistic about yours. Now, absent certain cases like murders and aggravated robbery, those are cases that are not going to get dealt because the district attorney is going to offer your client a lot of time, and you're not going to be able to take that. So that is going to be a trial. But generally speaking, mostly other cases, there should be it should be worked out if the two lawyers are doing what they're supposed to be doing. However, with people, sometimes they think, oh, well, I saw this on Boston Legal, or I think this, and I'm going to go and try it. And they don't realize there is a process. There are rules governing that courtroom. And just like how you said earlier, well, I'm going to tell my story. Really? Who's going to get that story in? So you have to understand that.
Okay. Last question. Well, next to the last question. Should the client really tell, even if they're guilty, should they tell their attorney every single thing? Or they, most of them will just say, no, I'm not going to tell you everything. I guess you have to figure it out. But should the person really tell their attorney the whole story, even if it's
Absolutely.
bad? Okay.
Absolutely.
And go with it from there?
Because your rights are protected because you have attorney-client privilege. So there's not your rights are forever protected with your attorney. Your attorney can never use them against you. Your attorney can never tell them to anybody. Or we can be disbarred. So everything you tell your lawyer is as confidential as telling you. So you absolutely. And the other thing is this lawyer by not telling him everything.
Okay. So if you rather
go ahead.
No, go ahead. I'm listening.
I always tell my clients, if you don't tell me everything, then you hurt yourself. You don't hurt me, you hurt yourself. because inevitably, if I'm blindsided by something, it's your fault because you could have told me.
Okay. So again, if you should tell your attorney everything. If you rob a store, just say, yeah, I did it, and then let the attorney kind of figure out how to resolve the problem.
Right. I mean, based on the fact, we'll know. I mean, come on. We do this all day, every day, so we're going to pretty much, I can put things together. But if I ask you specific questions, don't withhold information that you know can be pivotal to the case.
Okay.
I mean, for instance, I'll give you an example. I had a serious trial. This guy was on trial for very long. I mean, what they were offering a lot of times. And an important witness came in, and I said, do you know this person? He said, no. And I said, are you serious? Because they're acting like it's an important witness. He said, I don't know who it is. Come to find out, it was his next door neighbor. He knew who it was, but he was lying. How did that hurt him? It hurt him. I couldn't tell you how badly it hurt the case because she gave some information that was very damaging, and he should have told me the truth.
So he was proven to be a liar, and then that looks even worse.
Exactly.
Okay. What do you say to a person getting out of law school today who wants to start their...
What? Say again?
Yeah. In closing, if a person who's coming out of law school today who wants to start their own firm, what advice will you give that person who wants to start their own firm? Say, I want to go into criminal law. You
must get with a lawyer who has been doing this and learn the ropes. You must. Otherwise, you will do any client that you have a great disservice. This is not something... The stakes are extremely high with criminal law. Okay, so that means, once again, you're not playing with just money. You're playing with someone's life. And we take that very serious. So then that means that you need, in order to step into this position, you must align yourself with lawyers who know what you're doing and learn learn your craft. Because if you don't, you have the potential to affect someone's life for the rest of their life.
Wow. Okay. Great. But I really appreciate your time. I appreciate you coming on to the program. And anything else you want to close with before we go?
No, I appreciate you inviting me. I appreciate it. Was definitely a positive experience. I'm glad I got the opportunity, and I hope I helped some people. But I think the most important thing is just to, in cases with people always think, oh, this is my first time, especially if it's a criminal offense, or it's the first time I've ever been stopped, first time I've ever been arrested with a police officer. And my response is always, don't worry about that. The process can be handled. Just be honest and never ever give up your right. Always speak to your lawyer. Always wait and talk to a lawyer. It'll be much better for you.
Okay, and always be polite, but take the fifth.
Exactly.
Comments, great. I really appreciate that. How can a person contact you in the Dallas?
They can reach me. My number, I can give it to you. It is Sanchez Law Firm. The number is 214-277-9385. That's 214-277-9385.
And do you have a website?
Our website is actually getting ready to. It should be up and running in by the end of the month. So
okay.
Yeah, that is something we're definitely trying to finish up right now.
Okay. Do you have a domain address?
We actually, Sanchez Law Firm. Yeah, I believe it is.
Okay, great. And they can just search you by the internet in the Dallas-Fort Worth area, Jorge.
That is correct.
Sanchez.
I have offices. Right, I have offices in Dallas and in Austin, all over the state. And so I probably on a daily basis am in 8 different, I go to 8 different cities and all over Texas. So yeah, and certainly can find it.
Wow. Again, I really appreciate your time. I appreciate you coming on to the program. And again, Jorge Sanchez. And that number one last time to reach you
is 214-277-9385.
Great. I really appreciate it. Thank you, Jorge.
Thank you, Tim. I appreciate you. Have a good night.
Okay, have a good night. Take care. This has been another production of Apple Capital Group. Take care and have a good night. Thank you.